You're watching The Legal Breakdown. Glenn, Donald Trump may have just lost himself the friendliest judge in the entire country with what I think is a major misstep. Can you explain what just happened here?
Yeah, Brian, on the legal front, Donald Trump is always his own worst enemy. There's been some reporting that Donald Trump and his transition team are considering Aileen Cannon to be Donald Trump's attorney general. Now, this is really a big deal for a couple of reasons. One, she has absolutely no qualifications to be attorney general, but we'll set that one aside for the moment. Two, by Donald Trump considering her, and by this information being announced or being leaked, being reported, Donald Trump has probably finally done what is necessary to have her kicked off the case. Now, some people might say, well, there is no case at the moment because Judge Cannon dismissed Donald Trump's unlawful retention of classified documents, obstruction of justice, espionage case. And yes, she did, but she did it in a lawless way. She did it in a way that is unsupported by any precedent. So I'm fairly confident the 11th Circuit Court of Appeals, which is where the case is presently, will reverse her dismissal, will reinstate the case, send it back to the trial court, put it back on the trial track. And now I think it is all but certain Judge Aileen Cannon will not be the presiding judge. You know, Brian, we've all waited for a very long time to see if Jack Smith would file a motion to recuse, to remove her from the case after, one, she was appointed to the bench by Donald Trump, her benefactor, a very cushy and prestigious lifetime appointment as a federal judge. Two, she was reversed by the appeals court not once but twice early on in these proceedings. Why? Because she abused her judicial discretion and did something the law did not allow, to the extreme advantage of Donald Trump. And now she's gone and done it again. She dismissed his classified documents case with no legal basis to do it. So now that she is apparently being considered to be Attorney General of the United States, and that decision resides in the hands of Donald Trump, the defendant in the classified documents case, I don't think there is anybody who can say, you know what, her impartiality cannot possibly be questioned. It can be questioned, and with good cause. So I think this seals the deal, and I do not think we're going to see Aileen Cannon presiding in the classified documents case any longer once the 11th Circuit Court of Appeals returns the case to the trial court.
Well, Glenn, you know that the Trump team is going to look at this decision, this inevitable decision, not to return it to Judge Cannon and just say, we don't stand by any of that reporting. It was just the fake news. Is just the perception of her impropriety, is just the fact that this story exists enough unto itself for the 11th Circuit to still, regardless of what Trump's team says, to still refuse to give it to Judge Cannon?
Great question, and the answer is no. Why is the answer a definitive no? Because if you had to sort of jump at every shadow of reporting that was unconfirmed, maybe it was a product of Russian disinformation, who knows? But if any time anybody sort of put in the public square, oh, a president is considering something with respect to a judge, just, you know, by virtue of the fact that that information is in the public square, doesn't make it reliable enough for a judge to order a lower court judge to remove herself from a case. But here's what,
by the way, is a good thing, by the way, because then any purveyor of disinformation can just say something hoping to sway the case one way or the other. But then that raises the obvious question, why is this different? Why will the ABC News report actually have some heft as opposed to just, you know, this story being put into the news by anybody?
Yeah, great question. A couple of reasons. One, it is the cumulative effect. Even if no one fact standing alone would open her impartiality up to being questioned, which is the federal standard. Let me recite it, even though we've done this before and our viewers may be familiar with the statute, 28 United States Code 455, for those of you scoring at home. The language that requires a judge to recuse from a case is, if the judge's impartiality might reasonably be questioned, then the judge shall disqualify themselves, remove themselves from the case. It's a fairly low bar, and it can be courtesy of the cumulative effect of lots of different facts, like being appointed by the defendant, like abusing your judicial discretion twice in favor of the defendant, like dismissing the defendant's case with no legal basis to do it, and then being reversed again, and now on top of it, being considered for an enormously prestigious job, the Attorney General of the United States. The cumulative effect of that, I think, warrants at least serious litigation. Now, let me get to the litigation piece, Brian, because I think we just discussed how, a rank rumor or completely unreliable reporting about something doesn't mean that judges have to recuse or be removed from a case in knee-jerk fashion. However, I think if there is a motion to recuse filed, and perhaps even if there's not, there will have to be litigation. Just because ABC News reported it as coming out of or being a product of Donald Trump's transition team, Boris Epshteyn is the person that I saw named in the reporting as being involved on the transition team. There will have to be litigation to drill down and see if this reporting is accurate, is factual, and if, in fact, Donald Trump has considered or will consider Aileen Cannon to be the Attorney General in the extremely unlikely event Donald Trump retakes the reins of governmental power, wins the election. So this matter will have to be litigated, and there will have to be a ruling. And then, I suspect, given the cumulative effect, Judge Cannon will never see another day presiding over Donald Trump's classified documents case.
Glenn, who will ultimately make this decision to remove Judge Cannon from the case? We have, you and I have sat here and kind of puzzled at the fact that Jack Smith, even despite all of these instances where Judge Cannon's impartiality might reasonably be questioned, isn't the understatement of the century, and yet all that time he refused to go ahead and attempt it, even up to and including the point at which he just dismissed the case outright on some bogus pretense that all of a sudden special counsels are unconstitutional, even though they've been used since the 1800s. But that aside, he has refused to do it, and so who ultimately is going to make this decision? Is it going to be the 11th Circuit sua sponte, or is it going to be Jack Smith, who will finally deign to acknowledge objective reality that perhaps Judge Cannon is not an impartial arbiter of the law here?
Yeah, another great question, and this will probably be an unsatisfying answer because there are 4 possibilities regarding who will make the decision. So the first is the 11th Circuit Court of Appeals. They have the case right now on appeal regarding Judge Cannon's lawless, in my opinion, dismissal of Donald Trump's criminal case. So they could very well say, listen, 1, we reverse Judge Cannon for yet again getting it wrong to Donald Trump's extreme advantage, and we are sua sponte, on our own, sending this case back, remanding it to the trial court with the direction that it be assigned to a new judge, a fair, independent, impartial judge. I have seen federal circuit courts of appeal do that. So that's the first possibility. The 11th Circuit does it on their own. The next possibility is the 11th Circuit sends it back to a judge and orders that there be litigation on the question of whether she should remain the judge on the case, particularly given, 1, the reversal of the dismissal, if that's what the 11th Circuit does, and 2, the reporting about Donald Trump considering Cannon to be his Attorney General. Now, there are 2 possibilities once it goes back to the trial court. They could return it to Judge Cannon and say, listen, in the first instance, the federal law contemplates that you, Judge Cannon, will decide whether your impartiality now might reasonably be questioned, such that you shall disqualify yourself. So they could do that, and they could let Judge Cannon decide in the first instance. Of course, if she refused to recuse, that might go back up to the 11th Circuit, and they would have that question directly before them. Or they could actually remand it to a different trial court judge to litigate the issue of whether Judge Cannon should be removed, should recuse because of the cumulative effect of all of these circumstances. So that's 3. And the 4th, of course, ultimately, who might decide this question? The Supreme Court. And given that they have shown themselves not to be fair brokers of the law, all bets are off as to what they will do if they get the recusal issue before them. But those are the 4 possibilities. The 11th Circuit, Judge Cannon, an independent judge to make the decision about whether Judge Cannon should be removed, ultimately the Supreme Court. So lots of cooks in that legal kitchen.
And for this issue to even be considered, does somebody have to bring it forward? Does Jack Smith have to file a motion, for example, or file some evidence, including this ABC News story? Or are the judges just going to, on the 11th Circuit, just going to know that this story broke, and so they'll do it unto themselves?
Yeah, that's another good question. And so much of this is sort of uncharted waters because we're dealing with prosecuting a criminal former president for stealing our nation's most closely guarded secrets, really for the first time in our nation's history. So listen, if the 11th Circuit reverses Judge Cannon's dismissal, but sends it back to Judge Cannon without comment, well then Jack Smith had better get his motion writing pen out and write that dang motion to recuse and litigate the factual basis for the reporting that Donald Trump is considering making Cannon his attorney general, because that is disqualifying, with the defendant holding in his hands the possibility of giving this judge who's presiding over his prosecution, the very prestigious job of Attorney General of the United States. I'm sorry, in anybody's book, that's got to be disqualifying.
And will it be public if and when Jack Smith does file this motion?
Yes, there is absolutely no basis to file this under seal because it won't involve an ongoing investigation. It won't compromise witness security. There is no lawful basis. There's actually I believe, 6-part test if something is to be filed under seal, and this doesn't meet any of the elements to be filed under seal.
Given your experience as a 30-year federal prosecutor, how quickly would you expect this motion to be filed, knowing full well that the issue is being considered right now by the 11th Circuit to put this back on the trial track?
Well, it's interesting because I don't know that there's a vehicle to file, a procedural vehicle to file the motion now. Why do I say that? Because the case has been dismissed, so it doesn't actually exist as a pending
has Jack
case.
Smith, has he appealed it?
Yes, Jack Smith has appealed it to the 11th Circuit. So
right. So can he file a motion as part of his appeal which they're considering right now?
I think the answer is no, and here's why. Factual matters can only be raised and litigated and resolved, ruled on in the trial court. Appellate courts have no what we call original jurisdiction. The only thing they can do is saw the legal wood in front of them, and that wood, that cord of wood has been delivered to them once the case has been appealed. That's why, for example, in D.C., once the presidential immunity issue was appealed, Judge Chutkan was deprived of jurisdiction. She couldn't do anything. She couldn't act on motions. She couldn't litigate. She couldn't set motions hearing dates. None of it. But the appeals court only gets to decide those things that have been set in stone, factually speaking, by the time the case is appealed to them. So this would be a new motion. It would require new litigation, new argument, new factual determinations and rulings to be made by a trial court judge. So that's why this will probably not make its way into the 11th Circuit Court of Appeals opinion unless they decide to take note of the reporting. But as we've discussed, Brian, this is kind of it's a tricky one, because even if they take note of the reporting, they don't have fact-finding capabilities. So they couldn't even say, yes, we find as a matter of fact, Donald Trump is contemplating Aileen Cannon as a possible attorney general. Therefore, we're going to rule that she is now disqualified. I think that's not the way it's going to go. Let me finally, one more thing. Let me throw this at the viewers. It could be that if they reverse her dismissal, and I believe they will, they won't even have to take up the fact or the reporting that Donald Trump may appoint her as Attorney General, because they could say, listen, we now have this deep well of what I would call judicial misconduct, extreme favoritism to Donald Trump in a way that the law does not allow. 3 reversals, 3 abuses of discretion, 3 strikes, and you're out. So they may not even need to get to the Attorney General piece if they reverse her, because they'll have ample opportunity then to sua sponte on their own, say, by the way, we're sending it back to the trial court, but We are directing it be assigned to a fair, independent, and impartial judge, and that's not Judge Aileen Cannon.
Okay, well, obviously a lot to look forward to here. We will stay on top of this classified documents case and its hopeful return to the trial track. So for those watching right now, if you want to follow along, please make sure to subscribe. That's the best way to support our work. The links to both of our channels are right here on this screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.